Hello everyone, welcome back to the Margdarshak platform. So as you people are aware that we are doing the quick revision series, and in this series we are currently doing the polity through the articles, है ना? So as you people that are aware that the importance of the static portion in UPSC examination are increasing day by day as UPSC is making the paper tough in tougher side. So for making that paper tough, they are putting the static part in the more in the options. Okay, so that is why we have to focus more on static, and for that you have to have good command over the articles and the amendments, some portion of the important judgments for your polity section. Okay, so without wasting any time, we have to move towards the next set of articles, as we are done with the 207 articles in the last 3-4 sessions. So in this session today we are moving toward the next set of articles. So we are moving towards the next article, that is uh, article 208, that is the rule and procedures. So as you are aware that we are doing the states related articles, and in that article uh, we are in the chapter 3, that is the state legislature, the procedure generally. So basically in this article 208 mention about the rule of procedure for the state legislature, that is the each house make rules or for procedure and business for themselves only. Okay, next is existing rules continue till न्यू वन, यानी कि एग्जिस्टिंग लॉज तब तक वैलिड रहेंगे जब तक नया सेशन, सॉरी, नई असेंबली ना आ जाए, मतलब कि नए लोग नहीं आ जाए, नए मिनिस्टर्स एमएलएज नहीं आ जाए. ओके, गवर्नर में मेक रूल्स फॉर इंटर हाउस कम्युनिकेशन विथ कंसल्टेशन, यानी कि गवर्नमेंट इंटर हाउस, जैसे इंटर हाउस कम्युनिकेशंस के लिए रूल्स बना सकता है विद द कंसल्टेशन ऑफ द काउंसिल ऑफ मिनिस्टर्स. ओके, next is the article 209 that mention about the regulation by laws of financial business procedure. So it is basically mentioned the state legislature may regulate the financial business by law, that is mentioned in article 209. Okay, and next is a language to be used in the legislature, that is mentioned under article 20210. Okay, 210th article. Okay, it is quite important because nowadays we can see that there is an the conflict or some issue with the regional languages, like there is Marathi, that Marathi in the Maharashtra wala season वो system चल रहा है ना. So in that you have to remember that stay the languages to be used in legislature, that is mentioned under article 201. Okay, sorry, 210. Okay, next is the that is mentioned about the official language of state, Hindi or English. Speaker and chairman may permit other mother tongues. Okay, English may cease after 15 years unless law provides otherwise. यानी कि in the starting there is English was adopted for 15 years. Then with the amendments it has they increased the time period for the English. Okay, next is the restriction on discussion in the legislature, that is mentioned in article 211, that is no discussion on conduct of high court and supreme court judges. Next is the courts not to inquire into proceedings, that is mentioned in article 212, that is the validity of proceedings not questioned on procedural irregularity. Okay, officers members regulating procedure not subjected to court jurisdiction. Okay, next is the we are moving toward the legislative powers of the governor. So this is the chapter related to the powers of the governor. Okay, so it says that the power of the governor to promulgate ordinance, that is mentioned under 213th article. So now you have to tell me in the comment section ki which article mention about the power of president. Okay, प्रेसिडेंट की पावर के से रिलेटेड कौन सा है ना, ऑर्डिनेंस से रिलेटेड है ना. सो यू हैव टू टेल मी इन द कमेंट सेक्शन. ओके, नेक्स्ट इट मेंशन अबाउट द ड्यूरिंग रिसेस ऑफ लेजिस्लेचर, if immediate no action, then they can promulgate the ordinance. Governor can promulgate the ordinance, require president instructions if bill will with same provisions would need president's prior sanction. Okay, governor would reserve bill for president consideration. Act with same provisions would be invalid without president assent. Okay, so ordinance has the same force as legislature. Act must be laid before legislative assembly or both legislative assembly and council if legislative council exists, है ना. Next is the ceases to operate 6 weeks uh, from the reassembly or if disapproved sooner. Okay, so it basically can be operated for can be ceased to be 6 months maximum if not if disapproved before sooner, then it is dissolved earlier. Okay, next we are moving toward the high courts. Okay, high court. Okay, so this is the part this is the chapter related to high courts. Okay, high court in the states. Okay, so let's move toward the next article, that is the article 214, that is the each state shall have a high court, that is mentioned in the article 214, है ना. So tell me which article 213 किससे related है. Promulgation of ordinances, power of the governor. Okay, so next is the high court to be the court of record in 2000, sorry, 215th article mentioned high court as an court of record, that is mentioned in article 215. That is quite important from your exam perspective, you have to remember it for your examination. Okay, so it includes the power to punish for the contempt. Okay, contempt can be divided into civil and criminal contempt. Okay, okay, and the punishment will be decided accordingly. Okay, next is the constitution of high court, that is constitution of high court, that is mentioned in the article 216, that is chief justice and other judges appointed by the president. Who appoint the chief justice and the other judges of the high court, that is president. Okay, so appointment and condition of the office of judgment of the judges, that is mentioned under article 217. That is quite important from your exam perspective. Please remember these articles that I am putting start. Okay, so like putting stars, that articles are quite important from your exam perspective, you have to remember them. Okay, next is the that mention about the appointment by the president, warrant, hand and seal. Okay, next is the consultation with the NJS, that is National Judicial Appointment Commission, formerly CGI. फॉर्मल सीजी सॉरी फॉर्मल सीजीआई हो गया, गवर्नर हो गया, हाई कोर्ट चीफ जस्टिस फॉर अदर्स हो गया. ओके, so basically for the chief justice, the formal CGI and governor are part of this NJS appointment commission. And next, for the other judges, the high court chief justice is also going to be a part of this. Okay, hold office until 62 years of age additionally or acting as part of 224. Okay, may resign, एड्रेसिंग किसको एड्रेस करके रिजाइन कर सकते हैं, प्रेसिडेंट को. ओके, may be removed like Supreme Court judge, that is mentioned in the article 124 clause 4. Okay, office vacated if if appointed to the Supreme Court and transferred to another high court. Okay, office vacated if the appointment. Okay, next is the qualification for appointment. Basically citizen of India होना चाहिए, held judicial office for at least 10 years and been advocate for Supreme Court, sorry, high court for at least 10 years. Okay, so that is the qualification that require for an judges of the high court. Next is the age of the judges decided by the president after consultation with the chief justice of India, that is the final. Okay, next is the application of certain Supreme Court provisions to the High Court, that is mentioned in the Article 218, that is the Article 124 clause 4 and 5 apply. Removal of the judges. Okay, on the High Court judges. Oath and affirmation of the judges of High Court, that is mentioned in the Article 219 before governor or appointed person, that is mentioned in the Article Schedule 3rd of the Constitution of India. Okay, so you can remember that schedule third schedule is related to oath and affirmation. oath and affirmation. Okay, so you have to remember this. Next is the restrictions on the practice after being permanent judge, that is are mentioned in article 220. Can't played act in any court in India except Supreme Court or other high court. Okay, that is the restrictions on being judges of the high court, that is mentioned in the article 220. Salaries etc of the judges, that is mentioned in article 221. Salary determined by the parliamentary law or second schedule. Okay, next is the allowances, leave, pension rights, determined by the parliamentary law or second schedule. Allowances rights not vary to disadvantage after appointment. Okay, so next is the transfer of judges from one high court to another, that is mentioned in article 222. President may transfer. ओके, मतलब कि जजेस को प्रेसिडेंट ट्रांसफर कर सकता है वन हाई कोर्ट टू अनदर हाई कोर्ट ऑन द रिकमेंडेशन ऑफ नेशनल जुडिशियल अपॉइंटमेंट कमीशन. Okay, entitled to compensatory allowances. If they are going to transfer from one high court to another high court or one high court to Supreme Court, then they will get the appropriate allowances for that. Okay, next is the, so here you can find the case. Next, this here that we have seen that a judge of Supreme Court, judge of High Court from judge of Delhi High Court, लाइक है ना, उसमें केस हुआ था ना जिनमें उनके घर पे मतलब कि वो फायर फायर मतलब कि आग लग गई थी, जिसके कारण उनके मतलब काफ़ी ज़्यादा मतलब केस बरामद हुआ था, है ना. सो इन दैट केस दे ही वाज ट्रांसफर टू Allahabad High Court, that the way there he faced like protest and boycott. So that is, you can remember related to this, because you may find direct question in your examination related to the this power of the president, that does there is any power with the president that he can transfer the high court judges from one state to another. So yes, there is an power with the president. Okay, next is the appointment of the acting chief justice, that is mentioned in the article 223. That is, the president appoint other judges to perform duties if CGI vacate. Sorry, CJ, that is Chief Justice of High Court, vacate or unable to perform the duties. Next is the appointment of additional or acting judges, that is mentioned under article 224. That is, the president may appoint additional judge maximum for 2 years for temporary increase or arrear. President may appoint acting judge if judge absent or appointed temporary chief justice. Okay, no additional acting judges hold office after 62 years of age. Okay, appointment of the retired judge at the sittings of the high court, that is mentioned in article 224. NJS, that is National Judicial Appointment Commission, may request retired judge with the president consent to sit and act. Okay, entitled of allowances, jurisdiction, powers, and privileges of the judges. Like the acting judge is entitled to the same allowances and jurisdiction, powers, and privileges that are provided to the judge of the court. Okay, next is the power of the High Court to issue certain writs, that is mentioned in Article 226. Very important. This is asked with the Article 32. है ना? It mentioned about the fundamental rights, related to the fundamental rights, that they can ordinance a writ. Okay, so power of issue directions, orders, writ, habeas corpus हो गया, mandamus हो गया, prohibition हो गया, क्यो वारंट हो गया, certiorari हो गया. ये बेसिकली रीट्स है. 5 रीट्स होती है ये, क्या ना, सुप्रीम कोर्ट एंड हाई कोर्ट बोथ कैन मतलब कि हैव द पावर टू इशू कर सकते हैं दोनों. So basically high court can issue into under article 226, and supreme court can issue it in under article 32. Okay, for enforcement of article, sorry, part 3 rights, and for any other purpose. So basically jurisdiction of issuing writ is high, it's larger for the high courts and is smaller for the Supreme Court. Basically Supreme Court can only issue the writs for the part 3, that is fundamental rights, but the high court can promulgate or issue the writ for other purposes also. So that is how the bigger the ordinance, sorry, read power to issue the writ has broader uh, in the high courts. Okay, next is can exercise jurisdiction where cause of action arise regardless of seat and residence. Okay, application for vacation of interim order disposed within 2 weeks, power not to derogation of Supreme Court's power. So that is mentioned in article 32. So basically, you have to remember this statement can be asked, it can be asked in your upcoming examination because it is a very important statement. Okay, so basically Supreme Court has no power in derogation of the Supreme Court's power. High Court has no power in derogation with the derogation of Supreme Court's power. So application for vacant of the interim order disposable within 2 months, 2 weeks. Okay, next is the power of superintendence of all courts by the हाई कोर्ट. सो बेसिकली हाई कोर्ट से नीचे जितने भी कोर्ट्स आते हैं ना, सबॉर्डिनेट कोर्ट है ना, सो दे कैन ना have the superintendence power over them. Okay, so basically superintendence over all courts and tribunals within their jurisdiction, may call for returns, may make rules for practice and proceedings, prescribe forms, may settle tables of fees, and rule forms tables require governor's approval, does not confirm superintendence over armed forces courts and tribunals. Next is the transfer of certain cases to High Court, that is mentioned in the article 228. That is High Court may withdraw cases from subordinate case courts involving substantial questions of constitutional law, may dispose of certain case itself or determine law question and return. Okay, other so officers and servants and expenses for High Court, that is mentioned in the article 229, that is the appointment by the chief justice or directed judge and officers, and conditions for the service prescribed by chief justice rule with the governor's approval for salary allowances, leave and pension. So next is the administrative expense charge on the consolidated fund of India, fund of state, a particular state, that is the fees money taken by the court form part of that fund. Next is the extension of the jurisdiction of High Court or to Union Territory, that is mentioned in Article 230. Okay, so that is the Parliament may by law extend or exclude Supreme High Court's jurisdiction over Union territories. A state legislature can't increase, restrict and abolish such jurisdiction. That is the parliament has the power related to that of increasing the jurisdiction, reducing the jurisdiction of the high courts to the other states or UTs. Next, the reference to the governor under Article 227 for UT subordinate courts constructed as president. Okay. Next is the establishment of common high court for two or more states, that is mentioned in Article 231. That is the parliament may by law establish. Okay, establishment of common high court for two or more states, that is mentioned in Article 231. That is the parliament has power that they can establish high courts for for two or more than two states. है ना? So basically a reference to the governor in the article. Okay, reference to the governor in the Article 227 for subordinate court construction is the governor of the state where court are located. Okay, next is the appointment of the district judge that is mentioned in the article. Next we are moving toward the chapter 4, that is the subordinate court. So in the subordinate courts we are doing the appointment of the district judge, है ना? So basically appointment of the district judge is appointment postings, promotions of governor in the consultation with the High Court, that is mentioned in Article 233. Under the appointment of the High Court of the district judges, eligibility not in the not in union or state services, 7+ years as advocate or plater recommended by High Court. So next is the uh, recruitment of persons other than district judges, that is mentioned in Article 234, that is by governor or as per the rules after consultation with the state PCS and high court. So basically governor as rule, governor with the consultation of the state public service commission and the high courts. Next is the control over the subordinate court, that is courts, that is mentioned in the Article 235, vested in the high courts, including postings, promotions, leave of judicial service inferior to district judges, and does not affect appeals against the authorities of authorized non-compliance with the services. Next is the interpretation, that is mentioned in the Article 237, that is quite important. You have to remember that district judges include uh, city civil judges, additional and joint assistant district judges, chief justice of small cause courts, chief additional chief presidency magistrate, and the session additional assistant sessions judges. So it is the judicial. It also mentioned about the judicial services exclusive for district judges and inferior judges. Okay, so that is mentioned in the Article 236. Next is the application for of the provisions of the magistrate, that is mentioned in the Article 217 to 237, that is the governor may direct for public notification. Okay, so next we are moving toward the next set of articles that you have to remember. So let's move toward the next set of articles. Next we are moving toward the union territories, that is mentioned in the article part 4 part 8 of the Constitution of India. So in this, the Article 239 says, Article 239 says about the administration of the UTs. It says the president via administrator, a president administrator the union territories via the with the help of the administration administrator. Then that means that president appoint an administrator, lieutenant governor for the for the union territories, governor of the state as administrator for adjoining its duties. So sometimes the president may appoint the governor of the adjoining of the state to administer the UT. Okay. Next is the Article 239A, that is the local legislature and council of ministers, that is mentioned in Article 239A, that is the Puducherry Jammu Kashmir since 2019 and law by the parliament, not by Article 238. So basically council of ministers कौन से में है ना, सीओ basically Article 239 में mention है, that is the Puducherry Jammu Kashmir. Okay, so next is the special provisions for Delhi, that is mentioned in Article 239 AA है ना. So that is the union national capital territory ऑफ दिल्ली लेफ्टिनेंट गवर्नर के द्वारा होती है ना. एडमिनिस्ट्रेशन नहीं होता इसमें, एडमिनिस्ट्रेटर नहीं होता, लेफ्टिनेंट गवर्नर होता है. देन आफ्टर द लेजिस्लेटिव असेंबली, दैट इज द डायरेक्ट इलेक्शन फॉर कॉन्स्टिट्यूएंसीज, सीट फॉर शेड्यूल्ड कास्ट होती है, पार्लियामेंट रेगुलेट फंक्शनिंग होता है. देन लॉज ऑन स्टेट एंड कंकरेंट मैटर्स, they have power to make the laws on the state and concurrent list, that as the states do. And the parliament law prevail if repugnant, यानी कि parliament laws are always going with the added advantage. Okay, next is the council of ministers of the union territory. So basically it mentioned about in the maximum 10% of the assembly members. Okay, chief minister is the head and advice of lieutenant governor, that is the council of there is a council of ministers for the head and advice of the chief the lieutenant governor of the then NCT. Then after chief minister appointed by the president of India. Next is the chief ministers appointed by the president on the CM's advice. Next is the ministers next hold office during the president's pleasure. Collective responsible for legislative assembly. Differences refer to the president. If any difference arises, then it is referred to the president of India. Okay. So next is the failure of constitutional machinery, that is mentioned in the Article 239 AB. So next we are moving toward the Article 239B, that is the administrator's powers to promulgate ordinances. So basically स्टेट से रिलेटेड ऑर्डिनेंस हमने कौन से में आर्टिकल में देखा, 213 थर्ड आर्टिकल में, है ना. सो एंड फॉर यूटीज इट इज रिलेटेड टू 239B आर्टिकल. ओके, so you have to remember this. Okay, so it mentioned about the during recession of the legislature require president's instruction, not during dissolution or suspension. A deemed act of legislature 6 weeks after assembly or by resolution can be withdrawn by the administrator. Okay, so that is about the promulgation of the ordinances. Okay, next is the president's power to make regulation, that is mentioned in the article 240. That is the president's power to make regulations for peace, progress, good government, Andaman Nicobar Islands, Lakshadweep, Daman and Div. President make power to make regulation, that is mentioned in article 240. वो किसके लिए बना सकता है? For peace and progress, और peace, progress and good governance, अंडमान एंड निकोबार आइलैंड्स के लिए, लक्षद्वीप आइलैंड्स के लिए, दादरा नागर हवेली एंड दमन एंड दीव के लिए, पुदुचेरी के लिए, but can't make if the legislature exists such as Puducherry, Delhi, and for the Jammu and Kashmir. So can make if legislature dissolved and suspended, regulation can repeal or amend parliament, that is parliamentary act. Okay, so next is the high court for union territories, that is mentioned under article 241. So basically only union territory, that is that NCT Delhi, has its own high court. Other territories have shared high court with the states. Okay, so basically that is mentioned in the article 241, that is the high courts for the union territories. Parliament may constitute. Chapter 5 of the part 4 applies existing high courts continues jurisdiction. फिर होगा parliament can extend exclude state high court jurisdiction. Okay, so next is the next we are moving towards the panchayats. So we will do the panchayats today. So here we will try to complete the panchayats in the today's lecture only. So let's start the panchayat with the article 247, that is the definition of the panchayat, है ना. So it's about the district, ग्राम सभा, फिर इंटरमीडिएट लेवल हो गया, फिर पंचायत हो गया, पंचायत का एरिया हो गया, फिर पॉपुलेशन हो गया, फिर विलेज हो गया. So basically in 243rd article there it mentioned about the district, about the gram sabha, about the intermediate level of administration. Next up the panchayat area, then after population and villages, फिर ग्राम सभा's function, that is mentioned in article 243A. Okay, फिर हो गया constitution of panchayat, that is mentioned in article 243B. So please remember one thing, these are quite important. You can't leave them, or you can't afford to leave them, because you will directly found one or two direct question from panchayati raj institution, that is panchayats or municipalities, in your upcoming examination, as it is repeated multiple times in the history in the previous year papers. So please remember them, that you have to complete the panchayat thoroughly, so that while you are sitting in the examination hall, you will definitely going to get one or two questions from this part only. Okay, next is the constitution of panchayat, that is mentioned in the article 243B, that is the village, intermediate and district level. Intermediate level option below 20 lakh population. And next is the composition of panchayats, that is mentioned in article 243C, that is the direct election from constituency होता है, representation for chairman so chairpersons होता है, then after you can say represented by for representation for MLA and MPs हो गया, फिर हो गया representation of members of council of state and legislative assembly हो गया, legislative council हो गया. Next is the voting right of member and chairman, which mentioned under article 243C. Chairman's election manner is also mentioned under article 243C. Next is the reservation of the seat, that is mentioned in article 243D, that is the scheduled caste and scheduled tribes. Okay, So reservation, there is a reservation for scheduled caste and scheduled tribe, one third for women including SC/ST. Chairpersons reserved, or chairperson seat is also reserved for women and SC/ST. Then after rotation of reserved seats, as like sometimes HC के लिए सीट आ गई, कभी ST के लिए आ गई, कभी women के लिए आ गई, है ना. So this is how there is a reservation of the chair, rotation of the reserved seats. Okay, next is the seizures after Article 2 334 period. A state legislature can provide for backward classes also. Next is the duration of panchayat, that is mentioned in Article 243C, 43E. That is the 5 year from the first meeting. Next is the no dissolution by law amendment until term expire, election before expiry or within 6 months of dissolution. Constituted panchayat continues for remainder term. Okay. Next is the disqualification for members, that is mentioned in Article 243F, that is the state legislature law. Okay, so basically he have completed the age of 21 plus, है ना. Or next is the decision by the authority provided by the state laws. Okay, so basically these are the qualification for the membership. Okay, next is the यानी कि he should not be below the age of 21 years. Okay. So power, authority and responsibilities, that is mentioned in Article 243G, that is the institutions for self-government, devolution of powers and responsibilities, planning of for economic development और social justice हो गया, implementing 11th schedule scheme हो गया, that is mentioned in Article 243G. Next is that Article 243H, that is the power of imposing taxes by the panchayats, है ना. Panchayat have the power to impose the taxes and funds, that is mentioned in Article 243H, है ना. So here it is the authorizes the panchayats to levy or collect taxes, assign state government taxes, then grant in aid from the state consolidated fund, then after constitution of the panchayat fund, that is mentioned in Article 243H. Okay. Next is the finance commission, that is mentioned in Article 243I, constituted by the governor every 5 years. Review करता है financial position को और recommendation provide करता है. Okay, so that is under Article 243I. Next is the Article 243J, that is the audit of the accounts. Next is the election of the panchayats, that is mentioned under Article 43K. Quite important for your upcoming examination about the elections of the panchayats, that is mentioned in Article 243K, है ना. Vested in the election commission, यानी कि election commission is responsible for conducting the elections of the panchayats. Okay, state election commissioner appointed by the governor. So basically state election commissioner होता है, उसको basically governor appoint करता है, एंड कंडीशन और टर्म्स ना होती है ना, वो भी गवर्नर ही डिसाइड करता है. ओके, रिमूवल क्या कर रिमूव कौन करता है इनको, हाई कोर्ट का चीफ हाई कोर्ट जज इनको रिमूव करता है. ओके, सॉरी, रिमूवल लाइक हाई कोर्ट जज, यानी कि जैसे हाई कोर्ट के जजेस को रिमूव किया जाता है वैसे इनको रिमूव किया जाता है इलेक्शन स्टेट इलेक्शन कमिश्नर्स को. ओके, नेक्स्ट इज द एप्लीकेशन ऑफ यूनियन टेरेटरीज, दैट इज मेंशन इन आर्टिकल 243L, है ना. सो बेसिकली इट मेंशन appointment application of the union territories, that is mentioned in the Article 243L, with the reference to the governor become the administrator, references to the state legislature become the state assembly if any, and the president may apply with exceptions and modifications. Okay, so that is mentioned in the Article 243L, that is the application to the state union territories. Next is the part not to apply in certain areas, that is mentioned under Article 243M, that is the scheduled area हो गया, tribal area, that is mentioned under Article 244. Nagaland, Mizoram and Meghalaya, Manipur hill area with the district council, दार्जिलिंग गोरखा लैंड गोरखा काउंसिल एरिया हो गया, डिस्ट्रिक्ट लेवल पंचायत हो गया, फिर अरुणाचल प्रदेश हो गया, सुप्रीम कोर्ट सॉरी है ना, शेड्यूल्ड कास्ट रिजर्वेशन हो गया. सो बेसिकली इट इज मेंशन अबाउट कि in this part in these parts the application is the panchayat is not applicable. Okay, next is the continuance of the existing laws and panchayats, that is mentioned in Article 243N. Next, the bar to interference by the courts in electoral matters, that is mentioned in Article 243(o). So next we are moving toward the next is the about the municipalities. So for today, I think we are done with the important articles. So without giving you burdensome task, let's finish the lecture here, and we will meet tomorrow on the same time in the same time. So please watch these lectures full, है ना? So that you will get the maximum benefit out of that, and you can also refer to our Telegram channel where I will provide the PDF of these lectures, and the description of the Telegram, so sorry, the link of the Telegram channel will be provided in the description box. You can check out from there, and you can also get a link of the Google form where you get the mentorship program that is free for all people who are preparing for CDS, CAPF, ND or FCAT, है ना? So you can avail that program also. That is about the Margdarshak, so you can refer to that, okay, where we will provide the free mentorship and the planned, structured and materialized preparation for your upcoming examination. So without wasting any further time, let's revise by yourself through the PDF that I will provide in the Telegram channel. So we will meet tomorrow with the next set of articles. We will start tomorrow's lecture with the municipal council municipalities, okay. So that is for today. Good night, goodbye.